We now come to the backbench motion on whistleblowing. Sir Norman Lamb to move.
Thank you very much indeed, Mr Deputy Speaker. I beg to move that this House calls for a fundamental review of whistleblowing legislation to provide proper protection for a broader range of people. And I'd like to thank the honourable member for Stirling for the support in making the application to the Backbench Business Committee, together with all the other MPs who supported the application, and to the Backbench Business Committee, indeed, whose chair sits before me, for enabling this debate to take place, because I think it is on an incredibly important issue. And I want to start by telling 4 brief stories to illustrate why facilitating whistleblowing is just so important. Now, Mr Deputy Speaker, I was the Minister in the then Department of Health that initiated the review led by Bishop James Jones, of Liverpool, the former Bishop of Liverpool, into the horror of what happened at the Gosport War Memorial Hospital. And if you read his report from June last year, the very first chapter deals with nurses who in 1991 tried to speak up about their concerns about what was happening in that hospital. And yet the report refers to the silencing of nurses' concerns. It refers to a patronising attitude towards those nurses who tried to do the right thing. And the consequence of not listening to those nurses is the extraordinary and horrifying conclusion of that report that over 450 older people died as a result of the inappropriate prescribing of opioids. Old people who'd gone in for rehabilitation but came out having died because of inappropriate prescribing. And this, Mr Deputy Speaker, highlights the fact that we can be talking often about life and death situations. So enabling and empowering people to speak up literally can save lives. That, at its most clear and stark, is why this is so important. This horrific scandal at Gosport Hospital could have been stopped if those nurses had been listened to, and they weren't. And that in itself is an outrage. Scroll forward now to 2013. Dr. Chris Day, a brave junior doctor working in a hospital in South London, raised safety concerns about nighttime staffing levels in an intensive care unit. Now, it's in all of our interests that if there are concerns about the safety of any part of our health service, but perhaps particularly an intensive care unit, that brave people speak out. But what happened to him, because he spoke out, was unacceptable, wholly unacceptable. He suffered a very significant detriment. His whole career has been pushed off track. His young family have been massively affected by this. The junior doctor in that unit was put into an invidious position, being responsible for far too many people compared to national standards. So he pursued a claim against both the Trust and Health Education England. £700,000 of public money was spent by the NHS in defending against that claim, in large part attempting to deny junior doctors whistleblowing protection against Health Education England. Lawyers, disgustingly, were enriched. Late last year, the tribunal that eventually heard his case ended early after Dr. Day was threatened with a claim for substantial costs. He and his wife couldn't face the prospect of losing their home for their young family, and so he caved in. It is surely a scandalous treatment of a junior doctor. He was defeated by superior firepower. We have the grotesque spectacle of the NHS, of all organisations, deploying expensive QCs to defeat a junior doctor who raised serious and legitimate patient safety issues.
Will you give way?
I will.
Thank the honourable member for giving way, and I pay tribute to the work he's done on the Dr Chris Day case to really get the answers that I think we deserve about the way he has been treated. But I just want to ask him a little bit about the inequality of arms that many people, whistleblowers, face in tribunals. They've often lost their jobs by the time that they're at that point, and they really are, as you say, facing very difficult situations where highly paid QCs are really running rings around them, and actually it's often as a result of employers trying to find loopholes in the law to avoid liability.
Well, I thank my honourable friend for that intervention, and I thank him for his support in pursuing the Dr Day case, and I completely agree with the points that he has made. Sir Robert Francis, in his report Freedom to Speak Up in 2015, evidenced whistleblowers who'd given evidence to him, whistleblowers in the NHS, overwhelmingly experiencing negative outcomes. He talks of a hostile culture of fear and blame, isolation, reprisals and victimisation in our NHS, for goodness sake. And the stories continue. The impact on the individual can be devastating and profound. Being ostracised, abused and disadvantaged in your career. Dire consequences for your mental health. One nurse who tried to expose wrongdoing said, and I quote, "I would never put myself in that position again. I would rather leave." What a damning indictment on how we treat people in our treasured and cherished public service. I will give way.
I'm extremely grateful to the right honourable gentleman for giving way. He and I both worked a bit on the general issue of whistleblowing, and I pay tribute to his leadership on this matter, along with my honourable friend for Stirling, who I hope will catch your eye later, Mr Speaker. There are just 2 points I want to intervene on, the very good points that he is making. And they are these. We know 2 things, don't we? First of all, that across the country there is very strong concern about the way whistleblowers are being treated. We see it in the West Midlands, and he is articulating this point. But secondly, we know also that whistleblowers help ensure, through the role they play, that we have proper accountability and transparency. And in my view, the work that he has done and the work that others are doing on whistleblowing has not received anything like the amplification it requires.
I totally agree with the points that my right honourable friend makes, and he makes them very well. And I will come on to the point that he made in a moment. I'm just conscious, very quickly, but I'm conscious I'm nervous about the Deputy Speaker.
Just reassure, I hope I don't make anybody nervous, Dr. Conley.
Thank you, Mr Deputy Speaker, and thank honourable gentleman for giving way. He's most generous with his time. It was really a genuine question, which is, with the gentleman the doctor feeling under pressure from the overwhelming firepower and the cost potential to incur the NHS's quite substantial costs, can I ask what support this, the gentleman's unions, such as the BMA, or defence unions like MDU and MPS, might have offered him in terms of legal costs?
Well, in that case, rather shockingly, the BMA abandoned him, and that's a story in itself, which needs exploring further. But it's very often the case, not just in the NHS, but across the economy, where people are literally on their own, faced by very expensive lawyers. I speak as a former employment lawyer. I know what happens in employment tribunals. These were intended as a layman's court. They're anything but that these days, I'm afraid. The third story I want to mention is of my constituent Mark Wright, a successful financial planner at RBS. But things started to go wrong after he raised concerns about unacceptable practices in the bank before the crash that was. And then on the 17th of September 2008, immediately after the collapse of Lehman Brothers, an intranet statement was put up in RBS referring to the fact that the group was well capitalised. Now, this was clearly an attempt to reassure staff, and including staff shareholders and customers and investors, that the bank was secure. Of Of course, what happened when the bank crashed, those staff shareholders lost a fortune, and many believe, including my constituent, that they were very badly misled by that intranet statement. Now, his mental health was destroyed as a result of trying to challenge the bank, and his career was destroyed. He made a complaint to the FCA, the Financial Conduct Authority, who reported his name back to the bank, for goodness sake. They were later criticised by the Complaints Commissioner. I pursued his complaint with the FCA. They denied knowledge of the intranet statement repeatedly to me, yet an internal FCA email emerged dated the 14th of March 2014. That was after a subject access request to the Complaints Commissioner. And that email referenced, and I quote, "The intranet notice that Mr. Wright refers to was online between 17th of September 2008 and January 2009. And I quote, "As staff used it to take reassurance that all was well, which would tend to support Mr. Wright's allegations." That was an email within the FCA. Yet we were never informed of that email or of that finding of that explosive document. It's clear that the FCA has a copy of that intranet statement, yet they will not or cannot disclose it to us. They say that the law doesn't allow them. RBS, which is part state-owned, will not disclose it, yet clearly it is in the public interest that it should be disclosed. I believe I was misled by Andrew Bailey, the Chief Executive of the FCA, who told me in effect that Mark Wright's allegations offered nothing that was not already in the public domain. He referred to an intranet statement by Fred Goodwin, which had been, he said, in the public domain for nearly 10 years. And yet the statement, the intranet statement, has not ever been in the public domain. The Treasury Select Committee, which had looked into this, had never received a copy of it, so I was misled. So we have a regulator that's too close to the banks. We have a regulator that failed to protect his disclosure or his identity. We have a regulator that crucially appeared to fail to take the allegations seriously of the misconduct of that bank, and cannot or will not put a crucial statement into the public domain. Just think, Mr. Deputy Speaker, about the damage caused by bankers in the run-up to that crash. Had we actually empowered people like Mark Wright to do the right thing, rather than destroy them and ignore them, then we might just have prevented the disgusting behaviour and greed of bankers, and we might now have seen some of those responsible for destroying our economy behind bars. As it happens, they have got away with it. The fourth and final story is of foster carers who across the country are frightened to raise concerns about any behaviour from the council that they deal with. And of course the council refers children into their care. So if perhaps a foster carer is concerned about the behaviour of a social worker and raises concerns, that council can just stop the flow of children to them, and so disappears their income stream, their ability to earn a living. And so this has a chilling effect on any foster carer's willingness to speak out about child protection concerns because they fear losing their livelihood. I give way.
I'm very grateful to the Right Honourable Gentleman for giving way, but does that not highlight, whether in finance or NHS or anywhere else, it's in situations where you have a power differential and where you have a hierarchy, that someone actually has power over someone else that can make them lose their job or lose what they love doing, and therefore there's a constant threat?
The Honourable Lady is absolutely right, and that's why we need effective legislation to redress that imbalance of power. So, Mr. Deputy Speaker, all these cases highlight the value and importance of enabling people to expose wrongdoing. Effective protection, let me just make some progress. Effective protection for brave people who decide to speak out is vital, first of all, for that individual. They should be celebrated, not denigrated. But it's also in the benefit of all of us that we give them protection. And this is the point that the Right Honourable Member for Sutton-Coldfield made earlier. It's actually about good governance, this. Keeping organisations honest, protecting businesses from fraud, from crime and from other wrongdoing, maintaining the highest possible standards. Good protection to those who speak out acts as a deterrent to bad behaviour. Closed secret cultures which cover up wrongdoing and destroy those who try to speak up, deliver poor public services or cheat customers in the private sector, including particularly in financial services, or tolerate bullying, sexual harassment and so on. And then so often non-disclosure agreements are the final step that's taken that keeps that wrongdoing secret. It slams the door shut on proper scrutiny, and things need to change. So the question is, does the current law work? And palpably, from the examples that I've given, it is clear that it does not work. It leaves out, first of all, Mr Deputy Speaker, key groups, not only foster carers, who simply aren't covered by the legislation at all. It leaves out job applicants, volunteers, priests. Just think about the abuse of children by so many priests over the last few decades. If priests were given the protection to speak out, then perhaps we would have prevented some of that dreadful abuse. The legislation leaves out non-executive directors, it leaves out trustees, it leaves out relatives and friends of the whistleblower when they're victimised because of what the whistleblower has done. It leaves out someone who's victimised by being presumed to be a whistleblower. The company who thinks someone has spoken out, even if they haven't, and does something like dismisses them, they have no rights under this because they're not actually the whistleblower. That is a ludicrous situation. I give way.
Thank you very much. I'm grateful to the Right Honourable Gentleman.